Hey, good afternoon from ABC News headquarters in New York. We are interrupting regular programming because there is a major development in the case of Breonna Taylor, the 26-year-old black woman killed in her apartment by Louisville Metro Police during the botched execution of a no-knock search warrant in March. Kentucky Attorney General Daniel Cameron is about to announce the grand jury decision, which we've just learned. Charges against one officer for wanton endangerment, no charges for the other two officers who fired their weapons or the fourth officer who filed the request for the no-knock warrant, who also faced possible charges tied to discrepancies in how that warrant was obtained. The city of Louisville on edge under a state of emergency right now. Streets are blocked off and many buildings boarded up in anticipation of the decision. Protests there in Louisville related to Taylor's death, demanding charges for the officers involved. All of them have been taking place for more than 100 days. I want to go to ABC's Alex Perez right now in downtown Louisville. And this, no doubt, is a stunning decision, Alex. You've been covering this story from the get-go. And one of the things that stood out to me was that the victims named in the grand jury report appear to be neighbors of Breonna Taylor, but not Breonna Taylor or her boyfriend, Kenneth Walker, who were in the apartment when the shooting began.
Yeah, that's correct, Tom. What we heard from that judge who was reading the grand jury indictment, we did not hear Breonna Taylor's name. These charges of wanton endangerment relate to neighbors who were in that apartment complex. Now, this officer, Brett Hankison, he's the officer that has since been fired from the Louisville Police Department. He is contesting that firing, but he's the officer that's accused of firing his weapon aimlessly, not having a shot, through a wall, through a window. And the charges that he's facing based on the grand jury are related to that, endangering the people who were in that apartment complex. Now, this news is not going to be welcomed by the thousands here and across the country who have been protesting Breonna Taylor's death. Say her name has become the chant that we've heard across the country for some 6 months now, and those people have been calling for murder charges, the highest level of charges. That is not what we are seeing here. Also, we are only seeing charges against one officer. There are two other officers who were involved in that faulty, botched warrant that took place that night. Those officers were not mentioned at all in the grand jury indictment. Now, the anxiety here in Louisville has been building, not only for the last 6 months, but particularly the last couple of days. The city here, the mayor, the police department declaring a state of emergency. I want you to take a look behind me here. You can see these Louisville police squad cars. In the distance behind me, you can probably see those boarded up windows. All of downtown here, some 25 blocks, pretty much boarded up like that as authorities have been bracing for this decision. Now, in Jefferson Square Park, not far from where we are here, we see a crowd is building there. We're told many people there are crying as they listen to this decision. This has been an emotional 6 months for people across the country who have become involved with this story. And they see it not only as something that involves Breonna Taylor, but the bigger Black Lives Matter movement. And that's one of the reasons why we've seen this case take off on social media and in so many places, Tom. And right now, it's really unclear what the reaction is going to be because word of the grand jury indictment is just beginning to spread. But this city is prepared for anything. The Kentucky governor saying he's prepared to activate the National Guard if necessary. Downtown here has been essentially shut down for 2 days. Authorities here say they welcome protests that are peaceful, but they do not want to see any violence. We'll see in the next few hours how things unfold here and across the country, Tom.
And if you're just tuning in, on the right side of the screen there next to Alex, we are waiting on the Kentucky Attorney General to talk about this decision by the grand jury and announce these charges, which Alex just reported. Alex, before I let you go, I want you to stand by for us. I have one other question for you. You have covered this story inside and out for so many months now. What is your sense? Do the protests start immediately, or do you think it's going to be a very violent night once the sun goes down?
Well, Tom, it's really hard to predict, but what we've seen in other cases, other very tragic cases where the community has become involved, is that it takes a couple of hours for word to sort of spread and for some of these protests and protesters to organize. So the next few hours will be key. But, you know, we have to remember the court of public opinion and the court of law are two very, very different things. The public here asking for murder charges, but a prosecutor has to look at this from a legal perspective and bring charges forth that they believe they can prosecute and get a conviction on. It appears in this case, the evidence presented to the grand jury was not that, because what we saw were those wanton endangerment charges, Tom.
All right, I want to bring in Dan Abrams now, our chief legal analyst. And Dan, I want to just break down this case a little bit for our viewers if they're not familiar with it. Breonna Taylor, March 13th, just minutes after midnight, Louisville Metro Police go to serve a no-knock warrant, which essentially is they bang down the door and try to come inside to the apartment. She was with her boyfriend at the time, Kenneth Walker. When Breonna and Kenneth hear this knocking, Kenneth Walker's attorneys have said he asked who it was. He wasn't sure who it was. He feared for his life, so he fired. Louisville Metro Police returned fire, shooting and killing Breonna Taylor. She was shot at least 8 times. We now know some of the firing also hit neighboring apartments as well. We just heard the charges, wanton endangerment. Now, Dan, some people were demanding murder charges. They were demanding manslaughter charges. Explain exactly what is wanton endangerment for this one officer, Brett Hankison.
Right. Well, let's first take a step back for a moment. There's a dispute about whether the door was knocked on or not. The police said they did knock on the door. Kenneth Walker saying it didn't happen. And let's also start from the perspective to make it clear, Breonna was an innocent here. There is no allegation that she did anything wrong. So the question then becomes, as a legal matter, what is the responsibility of the officers? And you can see from the charge here, which is wanton endangerment, which is not reckless homicide. And the reason I'm comparing it to reckless homicide is because in both cases, you're basically talking about the same legal standard, which is that someone fired recklessly, wantonly, and in the case of homicide, the victim would have been Breonna Taylor. Here, the grand jury is saying the victims that we're charging for are the neighbors. Why? Because it seems that the grand jury believed that regardless of whether this was a good warrant and whether it was a warrant that should have been executed, they had a legal right to be there. And when they were fired upon, they responded. That doesn't mean that that's the answer that it should be, but that is the legal explanation for why there is no charge here with regard to homicide, because it seems clear the grand jurors did not believe that they acted beyond the scope of the warrant, except for Hankison firing that weapon. And he was already fired for that, using the exact same language, wantonly firing that weapon.
But Dan, explaining here, because people are going to say Breonna Taylor, as you mentioned, was just asleep in her apartment. She was with her boyfriend, Kenneth Walker, who had a license to carry a gun, according to his attorney. We also know that, according to the no-knock warrant, the postal inspector has said, because this all tied into an ex-boyfriend that Breonna Taylor had, police were alleging that apartment where she was staying at was allegedly receiving drug shipments. That's all in the no-knock warrant, but according to the postal inspector, they didn't know about this and they had never signed off on this or according to the postal inspector, spoke to the Louisville Metro Police Department about this issue. So if there are questions surrounding the actual warrant, we get to the point where Breonna Taylor is shot and killed, people are going to wonder here, how are the only victims in this case the neighbors?
Right, and I think that we need to separate out wrong from criminal. And again, I'm just explaining what the grand jury did here without making judgment on what they did. They clearly believed that it didn't rise to the level of being criminal because they had that legal document, that warrant, which allowed them to be in the house, to arrive at the house. Again, debate about whether they knocked or didn't knock, but no question they had this warrant. Now, looking back at whether that warrant should have been issued at all is a very important question, but that's a separate one from the officers who are now at the house with a legal warrant, and what did they do and when did they do it?
One of the officers, Sergeant John Mattingly, was shot in this incident as well. We do want to mention that. Dan, do we know if the grand jury's work is done? Do we think this is the end of this case right here?
I've got to believe that it is. I mean, I've got to believe that this is the indictment, because what a grand jury does not do is make announcements about who they're not indicting. We've seen this in the news a lot lately with James Comey and others who've gotten into trouble for speaking too much about people who were not indicted. So typically when someone isn't indicted, you simply don't discuss it, and the grand jury announces who they are indicting, which makes me think that what happened here is the grand jury evaluated evidence against all three officers, but in the end, or all four, and in the end decided just to hand up indictments with regard to one.
Dan, you're a legal expert. You've done probably thousands of these cases. From what you read about this case, from knowing this case and seeing the charges and seeing whatever evidence has been available to the public so far, were you surprised by the charges brought?
Well, look, I expected at least this charge, right? At least this charge, and I'm looking down to make sure that we get the exact correct language for the definition. But this wanton endangerment in the first degree charge. Why did I expect that? Because the police department had already fired him for firing wantonly his weapon. So I think that was kind of the base here. The question of whether there would be additional charges, I didn't know what the grand jury was going to do. Look, I know how maddening this must be to people out there who are saying, what about Breonna? What about her? Why doesn't she get justice here? And sometimes the legal system, doesn't work in that kind of linear way, and where the criminal law can necessarily provide justice. We have seen in a civil lawsuit brought by her family that her family has gotten a big settlement, but most importantly, major changes in the police department as a result of that settlement. So when the question is, should there have been criminal charges, it gets tricky when the police have the legal right to have been there, even if it was a bad warrant, but if they have the legal right to be there, they're then fired upon. It is tough sometimes to get an indictment with that sort of fact pattern. But again, I want to reiterate, that doesn't change the reality that Breonna was the innocent victim here, whether it's in that indictment or not.
All right, Dan, stand by for us. If you were just tuning in right now to ABC News, we are awaiting the Kentucky Attorney General to speak about the grand jury decision to charge a single officer in the Breonna Taylor case with wanton endangerment right now. If convicted on all charges, that could mean 15 years in prison. There are 3 counts right now. I want to go to Stephanie Wash. She is our reporter who's been covering this story from day one. She knows the attorneys. She knows the family members on all sides of this case. Stephanie, your take so far on what we've heard from the grand jury and from the judge.
Well, this was a city that was waiting. They've been waiting for more than 6 months for this decision to come down. I'm standing here in Jefferson Square Park right now, where a lot of protesters have been here at this makeshift memorial, protesting and speaking out, trying to get justice for this family. And there is outrage here right now. When they heard the decision, there was screaming. There was, oh, my God, what is this? So the people here are very shocked at what they heard. They're obviously here in support of Breonna Taylor and her family, and this is not what they wanted to hear today.
Pierre Thomas, our Chief Justice correspondent, there is also a separate investigation that the FBI is conducting. How will this play any role in what the FBI is looking at?
Well, they may have the final word. Their investigation is extensive, we're being told. They're looking at the circumstances of the shooting, how it took place, how the officers reacted to the situation. And to piggyback on something that Dan was talking about, this is a complicated situation in terms of, is justice being served? You have a situation where shots were fired and that young lady was killed, but now we're going to hear from the Attorney General.
Good afternoon. And thank you for joining us today. I know that many in Louisville and across the Commonwealth and country have been anxiously awaiting the completion of our investigation into the death of Miss Breonna Taylor. Prior to this announcement, I spoke with Ms. Palmer, Breonna Taylor's mother, to share with her the results from the grand jury. Many of you in this room know that I had the opportunity last month to meet in person with her and other members of Miss Taylor's family, including Miss Bianca Austin and Miss Janiyah Palmer. I want to once again publicly express my condolences Every day, this family wakes up to the realization that someone they loved is no longer with them. There's nothing I can offer today to take away the grief and heartache this family is experiencing as a result of losing a child, a niece, a sister, and a friend. What I can provide today are the facts, which my office has worked long and hard to uncover, analyze, and scrutinize since accepting this case in mid-May. I urge everyone listening today to not lose sight of the fact that a life has been lost, a tragedy under any circumstances. The decision before my office as the special prosecutor in this case was not to decide if the loss of Ms. Taylor's life was a tragedy. The answer to that question is unequivocally yes. There is no doubt that this is a gut-wrenching, emotional case, and the pain that many people are feeling is understandable. I deeply care about the value and sanctity of human life. It deserves protection, and in this case, a human life was lost. We cannot forget that. My job as the special prosecutor in this case was to put emotions aside and investigate the facts to determine if criminal violations of state law resulted in the loss of Ms. Taylor's life. This included examining the actions of Sergeant Jonathan Mattingly, Detective Brett Hankison, and Detective Myles Cosgrove, the three officers who fired their weapons in the early morning hours of March 13th. In working with our federal partners on this case, it was determined that while we would share information to advance our respective investigations, we must also maintain some level of separation to ensure the integrity of each investigation. When examining issues regarding potential civil rights violations, we determined that any such violations are better addressed through a federal-led investigation, and issues involving potential criminal acts concerning the shooting are better addressed by a state-led investigation. With this in mind, our investigation focused on the events that took place in Ms. Taylor's apartment on March 13th. In the months since taking this case, our dedicated team of prosecutors and investigators with more than 200 years of combined career experience conducted a thorough investigation to better understand the events that led to Ms. Taylor's death. The team is here with me today. I want to personally and publicly thank them for their tireless work. These men and women are true public servants who for months have shown up every day with a desire for one thing, and that is to seek the truth. We decided while we would examine materials gathered by LMPD's Public Integrity Unit, we would need to conduct our own independent investigation and start from scratch in the interest of thoroughness, fairness, and finding the truth. There was no video or body camera footage of the officers' attempted execution of a search warrant at Ms. Taylor's residence. Video footage begins at the point that area patrol officers arrive at the location. Therefore, the sequence of events from March 13th had to be pieced together through ballistics evidence, 911 calls, police radio traffic, and interviews. We utilized information from the Kentucky State Police, local medical examiners, as well as working with the FBI crime lab in Quantico to secure a trajectory analysis and ballistics report. Our team conducted interviews in this case and spent thousands of hours examining all of the available evidence. We concluded our last interview in this case this past Friday and began our grand jury presentation on Monday. As long as the case is making its way through our legal system, I can only speak in general terms about our independent investigation and findings. As the prosecutor, I am prohibited by the Kentucky Rules of Professional Conduct from making public comments that could in any way prejudice this case as it moves forward. Each state has different rules about what prosecutors can and cannot say. The Kentucky rules are clear that I'm prohibited from making comments that could sway public opinion or heighten public condemnation of those involved in the case. These are crucial rules to ensure due process under the Constitution. When prosecutors prematurely release information about the case to the public, it can risk justice by poisoning the jury pool, violating the accused's rights to a fair trial, and even jeopardizing the final verdict. The success of our legal system is predicated on the principle that the accused is innocent until proven guilty. Despite passions, opinions, and desire for every detail to be known, the rule of law must apply. Justice must be done. In the early morning hours of March 13th, officers from LMPD executed a search warrant at 3003 Springfield Drive, apartment 4. This was Miss Breonna Taylor's residence. The officers were advised by superiors to knock and announce their presence in serving this specific search warrant. The scope of our investigation did not include the obtainment of that warrant by LMPD's Criminal Interdiction Division. Federal law enforcement partners are conducting that investigation. Sergeant Mattingly and Detectives Cosgrove and Hankison had no known involvement in the preceding investigation or obtainment of the search warrant. They were called into duty as extra personnel to effectuate the service of the search warrant. They only had information conveyed to them during their prior briefing. Evidence shows that officers both knocked and announced their presence at the apartment. The officers' statements about their announcement are corroborated by an independent witness who was near in proximity to apartment 4. In other words, the warrant was not served as a no-knock warrant. When officers were unable to get anyone to answer or open the door to apartment 4, the decision was made to breach the door. After breaching the door, Sergeant Mattingly was the first and only officer to enter the residence. Sergeant Mattingly identified 2 individuals standing beside one another at the end of the hall, a male and a female. In his statement, he says that the male was holding a gun, arms extended in a shooting stance. Sergeant Mattingly saw the man's gun fire, heard a boom, and immediately knew he was shot as a result of feeling heat in his upper thigh. Kenneth Walker fired the shot that hit Sergeant Mattingly, and there is no evidence to support that Sergeant Mattingly was hit by friendly fire from other officers. Mr. Walker admitted that he fired one shot and was the first to shoot. In addition to all the testimony, the ballistics report shows that the round that struck Sergeant Mattingly was fired from a 9mm handgun. The LMPD officers fired 40 caliber handguns. Sergeant Mattingly returned fire down the hallway. Mattingly fired 6 shots. Almost simultaneously, Detective Cosgrove, also in the doorway, shot 16 times. This all took place in a matter of seconds. In total, 6 bullets struck Ms. Taylor. Medical evidence obtained by our team indicates that only 1 shot was fatal. Further medical evidence shows that Ms. Taylor would have died from the fatal shot within a few seconds to 2 minutes after being struck. Detective Hankison fired his weapon 10 times, including from an outside sliding glass door and through a bedroom window. Some bullets traveled through apartment 4 and into apartment 3 before some exited that apartment. At the time, 3 residents of apartment 3 were at home, including a male, a pregnant female, and a child. There is no conclusive evidence that any bullets fired from Detective Hankison's weapon struck Ms. Taylor. The KSP ballistics analysis did not identify which of the three officers fired the fatal shot. After receiving that information, I asked the FBI crime lab to conduct its own analysis to see if they reached the same results. The FBI ballistics analysis concluded the fatal shot was fired by Detective Cosgrove. Our office looked at both reports to determine if there were major differences in the procedures used by each lab that would have led the FBI to identify who fired the fatal shot. Both law enforcement agencies use similar equipment and analysis, and each lab is highly respected for their work. There was nothing our investigators could point to, nor anything provided by the respective agencies that directly explains why one lab made the call while another did not. I think it is worth repeating again that our investigation found that Mattingly and Cosgrove were justified in their use of force after having been fired upon by Kenneth Walker. Secondary to this justification, the KSP and FBI ballistics analysis reached different conclusions, creating a reasonable doubt in the evidence about who fired the fatal shot. I certainly understand the public's desire for answers, and many have questioned the length of the investigation. Simply put, we had to try every means necessary to determine who fired the fatal shot before the investigation could be completed. With a thorough and complete knowledge of all evidence collected in this case, lawyers with our Office of Special Prosecutions presented the findings of our independent investigation before a grand jury comprised of Jefferson County residents beginning on Monday and concluding today. In Fletcher v. Graham, the Kentucky Supreme Court said that the grand jury has competing but balanced functions. On the one hand, its purpose is to investigate allegations of criminal conduct and determine if there is probable cause to believe that a crime has been committed. On the other, the grand jury serves to protect the public against unfounded criminal prosecutions where probable cause is lacking. The grand jury is unique in our criminal justice system because it operates independent of the court and the prosecutor. The hallmark of the grand jury is its independence from outside influence. This independence is necessary to ensure that justice is done both for the victims and for the accused. After hearing the evidence from our team of prosecutors, the grand jury voted to return an indictment against Detective Hankison for 3 counts of wanton endangerment for wantonly placing the 3 individuals in apartment 3 in danger of serious physical injury or death. The charge of wanton endangerment in the first degree is a Class D felony, and if found guilty, the accused can serve up to 5 years for each count. Kentucky law states that a person is guilty of wanton endangerment in the first degree when under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. My office is prepared to prove these charges at trial. However, it's important to note that he is presumed innocent until proven guilty. During the last 6 months, we've all heard mention of possible charges that could be brought in this case. It's important to understand that all of the charges that have been mentioned have specific meanings and ramifications. Criminal homicide encompasses the taking of a life by another. While there are 6 possible homicide charges under Kentucky law, these charges are not applicable to the facts before us because our investigation showed, and the grand jury agreed, that Mattingly and Cosgrove were justified in the return of deadly fire after having been fired upon by Kenneth Walker. Let me state that again. According to Kentucky law, the use of force by Mattingly and Cosgrove was justified to protect themselves. This justification bars us from pursuing criminal charges in Miss Breonna Taylor's death. The truth is now before us. The facts have been examined, and a grand jury, comprised of our peers and fellow citizens, has made a decision. Justice is not often easy. It does not fit the mold of public opinion, and it does not conform to shifting standards. It answers only to the facts and to the law. With this in mind, we must now ask ourselves, where do we go from here? Will we continue to prosecute the charges brought in this case as it now proceeds through the justice system and moves to trial? That is our responsibility. And this will be done while the FBI continues its investigation into potential violations of federal law. I know that not everyone will be satisfied with the charges we've reported today. My team set out to investigate the circumstances surrounding Ms. Taylor's death. We did it with a singular goal in mind, pursuing the truth. Kentuckians deserve no less. The city of Louisville deserves no less. Every person has an idea of what they think justice is. My role as special prosecutor in this case is to set aside everything in pursuit of the truth. My job is to present the facts to the grand jury, and the grand jury then applies those facts to the law. If we simply act on emotion or outrage, there is no justice. Mob justice is not justice. Justice sought by violence is not justice. It just becomes revenge. And in our system, criminal justice isn't the quest for revenge. It's the quest for truth, evidence, and facts, and the use of that truth as we fairly apply our laws. Our reaction to the truth today says what kind of society we want to be. Do we really want the truth, or do we want a truth that fits our narrative? Do we want the facts, or are we content to blindly accept our own version of events? We as a community must make this decision. I understand that Ms. Breonna Taylor's death has become a part of a national story and conversation. But we must also remember the facts and the collection of evidence in this case are different than cases elsewhere in the country. Each is unique and cannot be compared. There will be celebrities, influencers, and activists who, having never lived in Kentucky, will try to tell us how to feel, suggesting they understand the facts of this case and that they know our community and the Commonwealth better than we do. But they don't. Let's not give in to their attempts to influence our thinking or capture our emotions. At the end of the day, it is up to us. We live here together. We work here and raise our families here together. I urge those protesting on the streets to remember this. Peaceful protests are your right as an American citizen. Instigating violence and destruction are not. I've spoken with both Mayor Fisher and Governor Beshears in the days leading up to this announcement, and I urge them to do what is necessary to maintain law and order and to protect our cities and our people. We have a long road ahead, both as we pursue this case through the criminal system and as we address the pain in the Louisville community. I'm committed to being part of the healing process. When tragedy occurs, we must mourn. We must also do everything we can to prevent it from happening again. Today, consistent with that view, I'm announcing that I will create a task force to review the process for securing, reviewing, and executing search warrants in Kentucky. The task force will consist of a variety of stakeholders, including citizens, members from the law enforcement community, representatives from the judiciary, defense attorneys, and elected leaders. I'll be issuing an executive order in the coming days to create this task force. I believe conducting a top-to-bottom review of the search warrant process is necessary to determine if changes are required and establish best practices. You have my word that I will also vigorously prosecute the criminal charges announced today. I can assure you that my team of prosecutors will continue to give this case their attention and time. We'll also continue to support the good men and women of our law enforcement community who put their lives on the line every day to protect and to serve. And I will fight for those across our state who feel like their voice isn't heard, who feel marginalized, judged, and powerless to bring about change. In a world that is forcing many of us to pick a side, I choose the side of justice. I choose the side of truth. I choose a path that moves the Commonwealth forward and toward healing. You have that choice as well. Let's make it together. Thank you, and God bless. I'll now take some questions.
Can you tell us what the racial and gender makeup of the jury was, the grand jury?
I won't get into the specifics of the makeup of the grand jury.
Yeah, just you mentioned that Breonna Taylor was hit by 6 bullets. You identified the one that killed her. Who shot the other 5 bullets, and did any of Hankinson's bullets hit Ms. Taylor?
Based on the evidence, there's nothing conclusive to say that Detective Hankison's, any of his bullets hit Ms. Taylor.
I'm just curious what your message would be to the family and those who support her in the community, because based on what you're saying today, the grand jury basically found that none of the officers involved are directly responsible for Breonna Taylor's death.
Well, as I said from the beginning, and I appreciate that question, this is a tragedy. And sometimes the law, the criminal law, is not adequate to respond to a tragedy. And I fully acknowledge that, and I know many that are watching today and those that are listening recognize that as well. But the response is that the grand jury was given all of the evidence, presented all of the information, and ultimately made the determination that Detective Hankison was the one to be indicted.
To be clear, did your special prosecutors make a recommendation to the grand jury?
Grand jury proceedings are secret, and so I'm not going to get into the specifics of details about that proceeding. What I will say is that we presented all of the information, and they ultimately made a determination about whether to charge. In this instance, they decided to indict Detective Hankison.
One question. Self-defense, do you think state law needs to be changed?
I'm sorry, say that again?
When it comes to officers firing back in self-defense, do you think the current state law needs to be changed for cases like this?
Well, what my role as the special prosecutor in this case was to provide the information and facts to the grand jury. Detective Cosgrove and Sergeant Mattingly were justified in returning fire because they were fired upon. I'll leave it to others to make determinations. We have vigorous self-defense laws in this state, and that is something that existed prior to this case. I'll let others make judgments about that. Yes, sir.
One big question surrounding this case is whether or not the officers knocked and announced their presence. Talk about the evidence that you came to that they did announce their presence.
Yes, the statements that were made by officers there the night or the morning of March 13th show that they did knock and announce. The important point here is that information was corroborated by another witness who was in close proximity to apartment 4, who corroborated that information and said that there was a knocking and announcing by the officers.
Was the witness a civilian or a law enforcement?
The witness was a civilian.
If a wanton indictment takes place while there is a death involved, would that not be a manslaughter charge? If there was a death that occurred during a wanton indictment?
Well, Chris, to your question, I think it, again, is important to step back and recognize that what we did was uncover all the information and facts related to the morning of March 13th, and then provided that information to the grand jury. The grand jury had every piece of detail needed to make their assessment and their judgments. And ultimately, their conclusion was that the decision needed to be made to indict Mr. Hankison.
Mr. Cameron, Rukmini Kalimaki with the New York Times. Right here, sir.
Yes,
hi, 2 questions for you. Number 1, you said that she was shot 6 times, yet her death certificate says 5. Can you please explain the discrepancy? And the second thing is journalists in this room, myself included, have taken apart that apartment complex looking for witnesses to the point that you made about the knocking and announcing. Of a dozen witnesses that I spoke to, only one, a man who was directly upstairs, heard them announce. Do you think that's enough in the middle of the night when somebody is asleep for just one person in a tight-knit apartment block to have heard that? Is that a sufficient way of announcing?
Well, let me try to answer your second question first. Your question was, is it enough for me? I think the more pertinent question is, what was the evidence provided to the grand jury? What was sufficient for their purposes? They got to hear and listen to all the testimony and made the determination that Detective Hankison was the one that needed to be indicted, knowing all of the relative points that she made. As to your first question, can you repeat it one more time?
Her death certificate says 5, and yet you are saying 6. Today's the first time I'm hearing 6.
Yes, sir. So there is a bullet that was lodged, and bullet might be too generous a term. There was an object that was lodged into into one of her feet, and so that is what is being referred to as the 6th, I guess, projectile.
Are you going to release the full? Are you going to release the full grand jury report?
Can you say that one more time?
Are you going to release the full grand jury report?
Well, I am. Right now, because there is a pending indictment, I think it is our practice, and because there is an ongoing FBI investigation, to revisit that question. But at this point, I don't think it's appropriate for us to release any information.
And just for clarification, you said that Hankison fired 10 times from outside into apartment 4 and into apartment 3, with no conclusive evidence any of those shots hit Taylor. Can you expand on that a little more?
Well, that is what the evidence shows, is that there was nothing conclusive to demonstrate that any of his bullets hit.
The door open for the fact that maybe one of the shots did hit him?
Well, again, all the evidence was given to the grand jury, and they made the decision that wanton endangerment was the charge to file or to indict against Mr. Hankison.
Okay, and thank you.
Yes,
How long this investigation has taken? Talk about the length of it, why it took so long, and why you were hesitant to provide information all the time.
Well, your last question about providing information. In any investigation, criminal investigation, the best practice, and this is whether on the state or federal level, is to not make too many specific comments about the investigation because you do not want to compromise that investigation. There are also ethical considerations as investigators and prosecutors that we're responsible to abide by as well. Some of those obligations continue now. Because we have a responsibility to pursue the prosecution against Detective Hankison. It's my judgment very early on that we needed to take this case in the Attorney General's office. As you know, the Commonwealth's attorney was conflicted out of this case because of another matter that he was pursuing. I could have farmed the case out to another Commonwealth's attorney in one of our 120 counties. Instead, I did not do that because the resources that we have to bring to bear and the relationships that we have with our federal partners, in my judgment, were needed to uncover the truth in this case. And part of the reason the investigation took so long is because we needed to make sure that we were doing a thorough job of looking at all the facts and gathering all the materials, interviewing witnesses, making sure that all of our people felt confident in their presentation to the grand jury. I will remind you as late as Friday, we were still interviewing people in this case. And so the length of it is because this case deserved thorough and fair analysis. That was needed and deserved by Breonna and by her family, for the officers involved, for the community of Louisville, and for the Commonwealth. We needed to have a thorough investigation. We also got the FBI involved in terms of the ballistics report. We needed additional, their ability to scrutinize and make an independent assessment as well. And so the length of the investigation was a reflection, I hope people understand, of how important it was that we got this right. We didn't want to rush it, and we did not. And I'm grateful to the team that is behind me for the work that they did. Look, over 200 years of combined experience. These are prosecutors and investigators who don't care about political distinctions, don't care about influence in any particular regard. What they care about is the truth. And we presented that to the grand jury.
Sir, sorry.
I'm sorry.
We've just been listening to Kentucky's Attorney General Daniel Cameron, who's called what happened to Breonna Taylor there in Louisville, Kentucky, a tragedy, but he now says the truth is before us. I want to go to Alex Perez, who right now is in Louisville, Kentucky, a city that is under a state of emergency. A lot of people think there may be violence tonight. There may be violence in the days to come. Alex, we learned two new pieces of evidence, two key pieces of evidence that the Attorney General wanted to highlight early on. One, that there was an independent witness who heard Louisville Metro Police knock and state they were police. So the no-knock warrant essentially did not happen, according to this independent witness. We also learned that Kenneth Walker fired first, hitting Officer Mattingly in the thigh, and then Officers Mattingly and Cosgrove returned fire. We learned that Breonna Taylor was shot 6 times, and that one of those bullets was from Officer Cosgrove. Does any of this change the justice calls for Breonna Taylor in Louisville tonight?
Well, Tom, arguably, no. You talk to people on the street, you talk to people across the country, they have been calling for stiff charges against all 3 of the officers involved. That is not what we saw happen today. We saw just one of the officers, Brett Hankison, charged with 3 counts of wanton endangerment. Those counts don't even involve Breonna Taylor. They involve the neighbors who lived in that apartment complex and putting them in danger by aimlessly shooting while he was carrying out that search warrant. Now, the Attorney General there went methodically through the case. Lots of information, and important to point out a few key things that we learned there. He said that Mattingly fired 6 shots and that Mattingly was the only officer to enter the apartment. He said that Kenneth Walker, Breonna's boyfriend, fired first, according to the Attorney General, and struck that officer in his leg. Now, we also learned that Breonna was shot 6 times, according to investigators. There's a discrepancy there because we had previously thought she had been shot 5 times, but the investigation has determined now there was an additional fragment or an additional bullet that Breonna Taylor suffered. Now, important here, new important information, the Attorney General saying that Hankison fired 10 shots, but there is no evidence that any of his bullets hit Breonna Taylor. And so as he was explaining that, the Attorney General means that the other 2 officers, Mattingly and Cosgrove, who did fire their weapons into the apartment, that means that the grand jury found that they, using their weapons, was justified. And because it was justified, the grand jury did not pursue any charges against those 2 other officers. Now, the Attorney General there also saying that the investigation showed that Breonna Taylor died just a few seconds after she was shot, before medical help arrived there on the scene. That all new information that the Attorney General there was trying to explain. Some would argue possibly trying to do damage control, because the calls out on the streets from these protesters gathering all over has been for months now murder charges for these officers. But the Attorney General explaining in length that murder charges in this case, the grand jury simply did not find that that is what the officers should face. So just one officer here charged with wanton endangerment, Brett Hankison. He's the officer that had already been fired from the Louisville Metro Police Department. The Attorney General also saying that the grand jury report is not going to be released at this moment. A lot of people want to see what was in that report. They want to see the evidence that the grand jury saw. Well, it seems it's going to be some time before we all get to see that report. Tom, that is the latest from here. This city bracing for any possible reaction. It's been sort of anxiety in the air, and everyone has been on edge, and we shall see now what the reaction to this decision will be. Tom?
And we are actually seeing our first pictures of people demonstrating, we should say gathering, assembling right now in reaction to the grand jury decision. I want to bring in Dan Abrams, our chief legal analyst. Dan, I was thinking about this as I was hearing the Attorney General, and unfortunately the reality is that innocent people are gunned down every single day across this country. What's so hard to understand in this case is that Breonna Taylor was in the wrong place at the wrong time, but that wrong place was her home. Right? It's her home. Her boyfriend fires on police. According to the Attorney General, he fires first. Police respond with 22 shots. 6 of them, or at least 5 of them, but at least 6 times she shot, one of them killing her. Now, for the people that are demanding justice for these officers, we understand one officer has been charged with the wanton endangerment. But from what you saw early on when you first heard these charges, you thought police were basically doing their job. And Breonna Taylor, unfortunately, was caught in the crossfire. But again, it's hard to believe the crossfire was her apartment.
Well, again, I don't know that I thought that the police were doing their job. I wanted to know more about what the evidence was going to be in connection with this case. And now the Attorney General laying out a lot more of that evidence. Think about it this way. When you're talking about justice, there's civil justice and there's criminal justice. I think it's important that we not ignore the fact that the city has settled a civil lawsuit, meaning without admitting wrongdoing, by paying $12 million and instituting a whole host of changes in the way they're going to do policing, they're admitting wrongdoing. So that's step one. Step two becomes, are there going to be criminal charges? And if you think about it this way, which is if the officers had a legal right to be there, and if you believe that Kenneth Walker fired first, it is hard to see how there would be charges against the officers who responded. Now, there are disputes about the facts. There are disputes about whether they announced themselves. There are disputes potentially about who fired first, et cetera. But when looking at it through a really strictly legal prism, it is hard to see if those two things are true, legally appropriate to be there in the first place, and was fired at by someone in the house, how there could be criminal murder charges filed against those particular officers.
The grand jury, by my count, deliberated for 2 to 2.5 days from what we learned from the Attorney General. What does that tell us about the amount of evidence and what they were thinking as they were deliberating?
Look, there's no question that in a case like this, the grand jury wants to be careful, wants to take their time. You don't need a unanimous grand jury in the state of Kentucky. Need 9 of 12. So I think that they certainly didn't want to be seen as rushing a very important decision here. And I think it is important to also recognize that, one of the officers has been criminally charged. But the Attorney General telling us that there is an eyewitness or an ear witness who says that he or she heard the officers announce themselves was, I think, an important development today, because that says that it's not just relying on the officer's account. Because when we went into this press conference, I said to you, there's this dispute out there. On the one hand, the officers say they knocked. On the other hand, Kenneth Walker says they didn't. The fact that there is an additional witness, a civilian witness who says that he or she heard the officers announcing themselves, does become another significant factor. And I think it's important to note, we talk a lot about these no-knock warrants, and they're very controversial. And I think that as time goes on, they're going to be phased out across the country. But in this case, they had a warrant, a no-knock warrant, but that order was changed. So they actually had to knock in this particular case, which is why that question is so important. Because if this was a no-knock warrant as a legal matter, I'd be telling you, look, they had the authority to go in there without knocking. Because that warrant was changed before they went in, or the order was changed, that does make it very significant whether they knocked first.
Dan Abrams for us. Dan, thank you for that. I want to go to Leah Rigor right now from Brandeis University. She's a law professor. And Leah, my question to you is, what does this mean going forward? We've had 6 months, 100 days recently of a reckoning across this country on race, on social justice, on how police cities and states across this country. What is this decision by the grand jury there in Kentucky? What does this do to the conversation and to the movement going forward?
Well, I think one of the important things to keep in mind is that the movement never stopped, right? Last month, we just had a march on Washington that was a direct result of the incident around George Floyd, but also Breonna Taylor and Ahmaud Arbery. So I think we should fully expect to see these movements, these protests, and even some of the more kind of, violent protests and riots continue, given that the justice system actually isn't affording justice to individuals across America, but particularly black individuals.
How will the movement interpret what we've just learned, the evidence just put forth by the Attorney General and the grand jury's decision? Again, I go back to this, the Attorney General saying this is a tragedy, but also saying the truth is before us.
So I think it's already happening. We saw that there are marches and protesting that are happening in this immediate moment. We saw that the lawyer for Breonna Taylor's family has already commented and said that this is essentially, to paraphrase, this is egregious, this is outrageous, and this is wrong. Breonna Taylor was sleeping in her bed. She did nothing wrong, and yet she was murdered. And the Attorney General admitted to that. Kentucky has admitted to it by paying out $12 million, which is not enough, but paying out money for the egregious death of this young woman. But we also learned today that, the police department and the Attorney General feel like justice has been meted out, and that in fact this was warranted, that her death was not was with claim. And so what you're going to see, I think, is in part people reacting to that. People are already reacting to that. People will be back marching. They will be back protesting because this is a reminder and a reinforcer that black people are without sanctuary and without justice in this country. So you're talking about a system that instinctively does not have space for these individuals. So how do you find justice for Breonna Taylor? And that's the real question, and that's what people marching and protesting are going to be talking about.
This case not yet over. I want to bring in Chief Justice Correspondent Pierre Thomas right now. And Pierre, the Attorney General there alluded to the issue with this warrant, the warrant in question. That's why police were on the doorstep of Breonna Taylor's apartment, and that the federal investigators are now looking at how this warrant was obtained.
Tom, that's going to be a very important part of this investigation. The FBI is looking at, was that warrant legally obtained? And also they will look at whether other violations were involved. Were the civil rights of Breonna Taylor somehow violated here? And that may involve looking at the past history of these officers, looking at the kinds of cases that they've made. Have there been any bias complaints against them? That will be a critical part going forward. But the issue here that's been raised is many people will be asking, do Black Lives Matter in a way where this young woman was killed, a series of mistakes potentially made, and there's no retribution in terms of the officers in this case. It's going to be a very interesting, difficult few days ahead for sure.
Several major questions still unanswered. The reaction coming in, the reaction out on the streets of Louisville, we'll see in the coming hours. We'll have much more on World News Tonight with David Muir. For now, I'm Tom Yamas in New York. We thank you for watching this special report.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.